I recognize the honourable member for Fox Hill.
I'm obliged, Mr. Speaker, to you and to the House. In keeping with my promise to keep the House informed on matters relating to immigration, I want to repeat the following statement, which was excerpted from an address to the Honorary Councillor Corps on the 15th of December. It relates to a ruling of Justice Petra Hannah Weeks in the case of Bruno Raffa in Freeport. And I quote, "I'm now studying a judgment recently issued in Freeport on a challenge to the authority of immigration. I await formal advice. However, my preliminary view is that in the face of such a wide-ranging judgment with which I respectfully disagree, and if it applies beyond the instant case, we are forced to consider our options where the country and the public interest demands the immediate removal of someone from the country, where, in the opinion of the Department of Immigration, the continued presence in the country of that individual may be inconsistent with the peace and good order of the country. You may hear more developing on this policy shortly. However, the basic premise seems to me to be to uphold that the Department of Immigration has to be, in the first instance, have an unfettered right to determine who is landed and excluded from the Bahamas, subject to law." End of quote. Mr. Speaker, the judgment in this instant case is the second time in as many months that judges of the Supreme Court in this country have given rulings which suggest that every case of a landed or non-landed migrant to this country requires the rules of natural justice to apply. If the situation were to stand as binding in law, this would effectively cripple the immigration laws as they've been applied in this country. It would mean that every case of a migrant to this country would be justiciable and possibly challenged in the courts on the basis that there is a legitimate expectation of natural justice. This particular ruling appears to go further, in that it suggests that this even applies to people who seek to enter the country as tourists. The public is asked to consider the following scenario, where a tourist is landed by an immigration officer, and then shortly after he passes the gate, the immigration officer discovers information that would cause him to cancel the leave. The ruling suggests that even though that might arise within the airport's precincts, there is a legitimate expectation of natural justice, and the individual has to be given a right to be heard rather than withdrawing the leave summarily and putting that individual on a plane and out again. One can imagine the chaos that this would cause with regard to the tens of thousands who make no attempt to come here legitimately but breach the borders and, pursuant to these interpretations of the law, would now require a court hearing before they can be removed from the country. For the moment, these rulings are interpreted as peculiar to their own facts. However, the rulings are given in such a sweeping and all-encompassing language that a careful study has to be made of them to see whether the law needs to be amended to provide the Immigration Department with the necessary authority to deal with matters summarily with regard to those seeking to land in our country and who, though not criminal, are judged not to be in the general public interest and not good to be landed in the Bahamas or to continue to stay here. The instant case in Freeport is particularly egregious in that the complaints are numerous and consistent about that individual, and the individual was put out of the Bahamas before because of his behavior. The present ruling will be examined to see how to deal with this particular case going forward. The matter is not at an end, but one must examine whether an appeal is necessary, given the declared position of his counsel that encourages people to fill the courts with legal actions in order to bankrupt the government. Here is the larger concern that all Bahamians of goodwill must consider, and I put them in the form of suppositions or questions, which are not to be taken as applying to any particular case. What is the Department of Immigration to do where the following obtains? Someone is landed as a tourist and has no work permit. That someone violates continually the immigration laws on the basis that he or she owns property here. That someone boasts that he or she has immigration in their back pockets up to the highest level, and he or she will go nowhere no matter what is done by officials, and will use the court system to outstay the present political administration in power. That someone continually verbally abuses and threatens Bahamians and makes racist remarks about them and politically charged remarks about the country and its officials. In these circumstances, when complaints are made to the department, what should the response of the Department of Immigration be? Under the existing way of operation, an individual can be given a choice to be formally deported or to be invited to leave the country voluntarily. The latter choice is often preferred because it at least preserves the possibility of a return to the Bahamas. In the former scenario, the individual is automatically restricted from returning to the Bahamas. Mr. Speaker, I say no more at this stage, and I leave the Bahamian public to consider this further, and particularly the people of Grand Bahama. But we will continue to act according to law. I also wish to say that the following is reported to me, that around 3 a.m. on the 19th of December, 2 Cuban nationals, one Jordani Gonzalez and the other Luis Alberto Ramirez, escaped from the detention center. This morning, and they are still at large. This morning, there are presently at the detention center 105 persons, 21 Haitian nationals, 59 Cuban nationals, and 25 various other nationals. And last week, on the 16th of December, 142 Haitian nationals were repatriated to Port-au-Prince. 3 Haitian nationals and 1 Dominican national were sent out on the 19th of December. Mr. Speaker, I'm advised this morning that 6 additional Cuban nationals were found at Gun Key and Bimini and are being brought to Nassau. Now, this present uptick in numbers from Cuba is believed to be driven by a belief amongst Cubans that the United States, their preferred destination, is about to change its policy, which gives Cubans an automatic right to some form of residence once they reach the U.S. mainland. I should keep the public informed. Finally, Mr. Speaker, I wish to take issue with an editorial that appeared in the Nassau Guardian at the 18th of December under the headline, "The Hypocrisy of the Bahamian Delegation at the Paris Climate Change Talks." The editorial is riddled with self-serving propaganda and non sequiturs. It is embarrassing and a discredit to whoever taught them the English language. Imagine describing the Prime Minister's lobbying on the issue of GDP per capita as whining, and then suggesting that the issue of the country's credit rating may extinguish that complaint. Economics 101 will tell you that the credit rating of a country has nothing to do with GDP per capita, and the issue that we must address if we are to get the money for adaptation and mitigation on the climate change matter. Be that as it may, however, the one issue amongst others I wish to address is the assertion that illegal immigration has yet to be addressed by the government. That is patently, obviously, and entirely false, ill-conceived, and misdirected. These folk must be blind as bats. What concerns us all on this side is the dumbing down of language by a newspaper of record which belittles the very label newspaper of record. For the record, then, I register my profound disagreement with all that is said in that editorial. And I thank you, Mr. Speaker.